probably Monday. Obviously we'll let you guys know. But today everybody should have two agendas that were sent to you. We had some late ads. So I'm going to start from the agenda that has 3 bills on it. First bill is going to be House Bill 289. This is a bill that comes to us from Department of Public Safety Commissioner Tyndall. Some of you were here, some of you weren't, when we had a big sweep bill of special funds into the general fund. This is putting those funds back. Basically, for example, there's a committee sub on here. The committee sub, like on line 28, there is a $6 fee that goes to Law Enforcement Officers Training Fund. That was originally a $5 fee. We're raising it $1. That would be for every type of traffic ticket given in the state. The person in part of the fine would pay an assessment of $6. That $6 would be set aside to go to, in this case, the Law Enforcement Officers Training Fund, which is trooper school academies or law enforcement academy out at in Rankin County. We also, you'll look through here, the other things we give to are the Administrative Office of Courts. We're offering an assessment for them for basically the same traffic violations, DUIs, felonies, and the like. And we're also adding money to the Mississippi Forensics Laboratory account. What that is, y'all remember back in December, we had a hearing on the medical examiner. This is putting money in to pay for some of the problems that the medical examiner's having, and possibly to include a new medical examiner's office up in North Mississippi. So those fees are being put back in and put over to public service and to the AOC. That is, let me make a conceptual amendment as well. I was basically asked to, there was a 95-cent fund, Gwinnett, that went to the DeBarge School in Hattiesburg that we're going to put back in here too. That was taken out and swept. So I want to just conceptually put that back in. I don't remember what part it was in, but I was asked to put that back in. So that's the amendment. Anybody opposed to that amendment? Okay. Okay, so that amendment carries. Now, the also second amendment is, I'm going to put a reverse repeater on this as well. Anybody opposed to that amendment? Okay, so that amendment carries. Yes. So that amendment carries. So motion is title sufficient do pass, committee sub as amended. Anybody opposed? You the only one, Jeff? You're the only one, aren't you? Okay, motion carries. Motion to reconsider, gentleman from Rankin. Motion to table, gentleman from Pike. Okay. That one is gone. Moving right along, lady from Madison, I recognize you to handle House Bill number 1140.
Thank you. Can you hear me? Okay. Thank you, Mr. Chairman. This is an important bill to me, and I thank you for allowing me to present it. House Bill 1140 amends the code section which addresses the killing of a human. It adds that a person 18 years of age or older that engages in the unlawful distribution or mixture of a substance that is proven to be the cause of death of the deceased shall be charged with first-degree murder. It also brings forward code sections for causes of death and those that provide penalties for violation of the Controlled Substances Law. As I stated earlier, this is an important bill to me. I know of at least 8 families in Madison County alone that have been impacted by these crimes. In fact, many of them are watching this meeting this morning as we speak. And I know that there must be hundreds of families from each of our counties that would benefit from House Bill 1140. Just last night, I received a letter. The Lafayette County Metro Narcotics recently reported that within the first 13 days of this year, within the first 13 days of 2021, there had been 4 overdoses, 3 of which resulted in death. The trends seen over the last couple of months in Oxford is prescription drugs being pressed with fentanyl, along with fentanyl and meth, ecstasy, and heroin. I'm hopeful for a revelation to be given to those that deal in the distribution and mixing of drugs when they realize that the accountability of their actions will be much greater once this becomes law. So in summary, Mr. Chairman, House Bill 1140 is a life-saving bill. And again, I appreciate you allowing me to present it. And I do believe that you have an amendment. Is that correct?
I have an amendment. Thank you for recognizing me for the amendment. Yes, I'm going to ask that we, again, this bill needs to go through the process. It really does. I appreciate the intent. I appreciate what the bill is trying to do, but I want to add a reverse repealer as well and move this along. Oftentimes we file bills that are good legislations, but they can always be better, and I think this bill can be better. So the amendment is a reverse repealer as well. Anybody opposed? All right. The amendment passes. Lady, what is your, wait, let me ask, any questions for the lady? Okay. Where's she from? Lowndes. Lady from Lowndes, unmute your, there you go.
Yes, I have a question. So in the instance where you have 2 young people in college, they have drugs, they both take them, one dies, the other lives. The one that lives could be the one that's charged with first-degree murder, even though the victim, the decedent, took the drugs, but the drugs were the proximate cause of the death. This was a case that actually happened in Starkville. And a best friend was charged with first-degree murder. And I don't think that should be the case. So I'm against the way this bill is drafted.
And I'm hopeful that this is part of what he was talking about, the kinks being worked out. But I do appreciate that. I think I know the case that you're talking about.
Mr. Chairman,
You're recognized, gentlemen.
would it be fair to say that some of the concerns that the gentlelady from Lowndes County has are some of the things that we're going to try to address in the repealer that you've discussed?
No, that's exactly right. And we want to narrow this in and go to the problem instead of having these unintended consequences. And that's why we put the reverse repealer in it, to study this further down the road.
Thank you, Mr. Chairman.
Thank you.
Mr. Chairman,
Okay, gentlemen from Pearl River.
are we looking at maybe when we're going through the process, the penalty of first degree, are we looking at maybe, some sort of manslaughter or something like that? A little bit, just for instances like Dana was talking about, that sounds more like negligent homicide. And I'm just wondering if we're looking at the penalties in addition to the unintended consequences.
Yeah, I believe the lady will agree with me. I don't want to interrupt, but yes, that's the intent of the chairman anyway, is to look at those ideas. Lady, hold on. Gentleman from Madison.
Thank you, Mr. Chairman. I have shared the same concerns that have been expressed as well. I would offer an amendment if you would be open to it. One way to fix it would be to amend it on line 35 by adding the words "with deliberate design," That whole code section all has the words with deliberate design all through the other criteria. If we added that here, it would eliminate a situation where two friends, because that's a common occurrence, right? Two friends are messing around, one of them dies, and it comes down to who touched it last. And often they're best friends, often they're family members, it's brother, sister, it's cousins, and then somebody gets charged with first-degree murder when, you know, it was sort of they touched it last. So I think that whole code section has with deliberate design. So if we amended on line 35 by inserting with deliberate design in that section E, that would fix the situations that the concerns. So with your permission, Mr. Chairman, I would offer that amendment.
Let me recognize the lady. Do you have any response, lady from Madison?
I would like to just be able to say that I'm hopeful that this is the kind of stuff that's going to be worked out when you go to conference. You're putting reverse repealer in it, correct?
It is, and I believe the issue and what the gentleman's talking about, yes, that's something that we.
And I believe the intent here is for drug dealers, those that are distributing this. So I understand where you're coming from completely. I'm really going to leave it up to you, Mr. Chairman. Do you think that this is an amendment that needs to be made, or is this something that you're going to deal with when you go to conference?
I'm going to leave it up to the committee, but I personally don't have an issue with the amendment, and it's something that certainly will be further dissected as we go further through the process.
Okay, sure.
Let me see, lady from Pearl River.
I ask that we deny the amendment. That amendment basically lets everybody off the hook and deletes the purpose of the bill. I agree with the reverse repealer, go through work, tie in the language, but the word language that he's using basically holds no one accountable.
Are any other questions on the amendment before I let gentlemen close on it? Any other questions? All right, gentlemen from, hold on. Lady from Lowndes, this is on the amendment.
Okay, well, I'm just concerned about depraved heart murder, whether this would also be included in that. Because those are instances in which friends can be charged, and it is indeed a first-degree murder charge.
Again, that's an issue that we're looking at going forward. My overall feeling of this bill is it will not end up as a murder charge. My opinion is it's probably going to be dropped down to some type of manslaughter, but I'm going to keep it alive like it is. That's why we got the reverse repealer in it. But your issue is a valid one. Any other questions on the amendment? Gentleman from Madison, anything further?
Yeah, Mr. Chairman, I just think with the language I'm suggesting, it gives the opportunity to charge anybody, because if a drug dealer is dealing drugs, it's with the intent, with the deliberate design of people taking large quantities of those drugs, which would allow the charge for first-degree murder. But it's also going to be very clear if it's a cousin or a friend or a loved one, a family member, obviously you're not going to meet that with deliberate design criteria if they're best friends, which again sometimes happens. So to me, it gives the judge the latitude to charge that, but it also gives an escape valve in situations where best friends, loved ones, and family members happen to be the one that touched the drug first or touched the drug last before the person who took it. So I would stand by the amendment and request that we vote on it.
All right. Any on that? Let's vote on the amendment. All those, we're going to do the same way. All those against the amendment, let me see your hands. Okay, amendment carries. Now on to the bill. Are there any further questions on the bill? Okay, motion is, lady.
Title sufficient do pass as amended.
That's correct.
Okay.
Although anybody opposed?
I am.
Okay, I see two. Two, three. Okay.
It's more than two, Mr. Chairman.
Okay. Well, I still see a majority for it, so I'm gonna call it for that the bill passes. Motion to reconsider, gentleman from Rankin. Motion to table, gentleman from Wayne. That one is and for the record, I saw, I think, 4 hands. So for the, that one is gone. Okay, now let's move along to, I'm gonna go back to the big agenda. And I'm gonna recognize the gentleman from Scott for the first bill, House Bill 87.
Thank you, Mr. Chairman. Members of the committee, this is House Bill 87. This comes from us from the Department of Human Services, and what they're asking for is that their investigators have law enforcement status or law enforcement authority. At the current time, our MDHS investigators must be law enforcement officers to be certified to be hired. But however, the way the law is written, they're not considered law enforcement on the job. They have to have a second job to have that law enforcement certification. So this law basically allows them to have that without having to have a second job. It's supported by the Sheriff's Association and the Association of Chiefs of Police. There's not any questions. I'd like to ask title sufficient to pass.
Are there any questions for the gentleman? I saw Rankin County first. I don't know, but anyway, that's what I saw. So let's go ahead, gentleman from Rankin.
Gentlemen, with this a few years back, and this has been a lot of years back, but they took auditors from the state auditor's office and made them law enforcement officers with no law enforcement training or anything else. That's not what this is doing, right? These are law enforcement officers that are being put there.
Yes, sir. They already have to be law enforcement certified to be hired as investigators. This would just allow them not to have to moonlight with a second job.
Okay, thank you.
Gentleman from Jackson.
Thank you, Mr. Chairman. Representative, are we expanding any authority under this bill, or is it the same authority?
It's the same authority. We're not, they're already doing the job as this already. This just allows them not to have that second job, because what's happening is they're working a second job as a law enforcement to have this certification, but then our MDHS investigators are being hired out from up under the state.
Any further questions? All right, gentlemen, what's gentlemen, what's your motion?
Title sufficient to pass.
All right, all those in favor? Anyone opposed? All right, that one passes. Gentleman from Scott, motion to reconsider. Gentleman from Wayne, motion table. That one's gone. Next one, gentleman from Mr. Vice Chairman, I've got you down handling 2 bills, House Bill 188. Go ahead and do that one, and then I'll recognize you for both of those once you get done. But we're on House Bill number 188.
Thank you, Mr. Chairman. 188 comes at the request of the Veterans Affairs Board and Corrections. There is a unit in, I believe it's in Rankin County, that's specific for veterans who are imprisoned for nonviolent crimes. This basically gives them a little leeway in what they can do in their training and what their uniforms. And that's a basic description of the bill.
Any questions for the gentleman? All right, seeing none, what is your motion?
Title sufficient to pass.
Any opposed? All right, motion carries. Motion for reconsideration by gentleman from Rankin, motion to table by gentleman from October Hall. That one is gone. Mr. Vice Chairman, if you would handle House Bill 551.
I'm not familiar with that one, Mr. Chairman.
Okay, I'll handle it real quick. I'm sorry I had you down. This is the same bill we passed last year. Driver's license allowing what I think it went passed out unanimous on the floor. MDOC, when they get out of MDOC custody, giving a state issued, using their ID from MDOC as a valid not driver's license, but as a valid state ID. It helps them to get a job, helps them to get a driver's license down the road, but we're just authorizing that their MDOC ID can be used for a period of year as a valid state ID, and that's an explanation of that bill. Any questions? Yes, ma'am. Lady from Harrison.
Yes, Mr. Chairman. Could we not amend this to just issue each person that is exiting MDOC's custody a state issued ID so that when they go before an employer, they don't have to, it won't be sitting there that they were just in custody of MDOC, but they actually have the same state issued ID that any other citizen that would go out and apply for one and have one. Could we not amend that?
Let me go back. If you have the bill in front of you, and I may have misspoke on that as their MDOC ID. On 95, it says the department shall promulgate rules that allow an official identifying document issued by the Department of Corrections to serve as an identifying document. So what that says is that it doesn't necessarily have to be their MDOC where it says I was a convict or I was a prisoner out of MDOC. It can just be a generic, if you will, state issued ID that is issued by the Department of Corrections.
Okay, but is it going?
Go ahead.
Is it going to be the same ID that if I just wanted to go get a state ID?
That's a question that's left up to, we're giving MDOC the authority to promulgate those rules. So that's a question that would be left up to MDOC. Let me understand your amendment. Your amendment is you're on mute. State it again.
Every person exiting the custody of MDOC is to receive a state issued identification.
Okay. Conceptually, I don't have an issue with it. I'll recognize you for that amendment. We can go through the process. I think we're trying to accomplish the same thing.
Okay.
Okay. Lady from Hines, Ms. Gibbs.
Good morning. Thank you, Mr. Chairman. I just want to get clarification. Is this the same type of ID I think we talked about with the homeless receiving? I think we talked about the homeless also, same type situation in this case as well?
It's the same type. It would be certainly a different type. I guess a different MDOC would be authorizing the ID, but yes, it's the same concept. I'm familiar with what you're talking about, allowing an ID to be given to homeless so that they could potentially likewise get a house and/or employment from that. It's the same type of, yes.
And so with these IDs, will they be have expiration dates on them? You know, meaning that they can continue to get one, or it's for a certain span of time? I'm trying to see if any fee is associated with giving these particular types of.
No, the ID issued by MDOC, the only qualification of that is it can be used in lieu of a birth certificate, social security card, if they were released within the last 12 months of incarceration. So it's not, the ID doesn't have a expiration date, so to speak.
It's a date, okay. Thank you, Mr. Chairman.
Chairman, this is Representative Yates. My video is not working, but I have a question whenever it's my turn.
Okay, I don't see anybody else. Go ahead.
So when we had hearings last year in corrections, and I think maybe even a joint corrections and JEDB hearing, the main issue that I recall hearing from the Department of Corrections was that there was sort of this backlog of prisoners who were ready to be released on parole or just released because they had finished their sentence, but they had no proof of residency. And without proof of residency, they weren't able to have an ID issued. And so it was just sort of this circular problem. I'm concerned that the way in which this is drafted doesn't eliminate the issue of proof of residency. Because as the rules exist right now, in order to get your ID, you have to show proof of residency in addition to a birth certificate or a social security card. The birth certificate and social security card do not serve the purpose of establishing residency. So I would just ask that we look at this and make sure that we're accomplishing what is actually needed to rectify the problem before we present this on the floor.
I understand. Thank you for that. Lady from Harrison, I want to recognize you back. I don't know that we voted on that amendment. Let me ask you, lady from Harrison, are you making that amendment?
Yes, sir.
Okay, all right. Let's go back. The amendment basically says that, repeat it for everybody if you don't care, lady.
Every person exiting the custody of MO in Mississippi Department of Corrections will receive an official state identification card.
Okay, that's the amendment. Anybody, show me those opposed. Okay, the amendment will carry. And lady from Hines, I'll commit to you that I understand what you're talking about. And I think there is also a bill in transportation that takes up the residency issue that you're concerned with.
It does.
So I understand where you're going from. With that said, any other questions on the bill? Okay, I'm going to make a motion, title sufficient, do pass as amended. All those opposed? Okay, motion carries. Motion to reconsider, gentleman from Rankin. Motion to table, gentleman from Tippa. All right, I'm going to recognize gentleman from Pearl River to handle House Bill 290.
Thank you, gentlemen. House Bill 290 comes to us from the state auditor's office. It's a very short bill. It's a one-pager. All it does is prohibits individuals charged with public embezzlement of an amount over $10,000 from being able to participate in the pretrial intervention program. For those of you who don't know, pretrial intervention is a way somebody can take care of a felony charge without getting a felony conviction. This would just keep public officials who have embezzled from the taxpayer from being able to participate in that program. And that's an explanation of the bill.
Gentlemen, and this is only specific to public officials, correct?
Correct.
So if you have a hypothetical, if you have someone working at a, let's say a liquor store who embezzles some money out of the petty cash that's less than that's more than $10,000, would they still be eligible for pretrial diversion?
They would. Okay. This is for the deputy tax assessor who embezzles $11,000, or the chancery clerk who sneaks 25 grand out through the desk.
All right. Any questions for the gentleman?
Mr. Chairman, I have a question.
Okay, lady from Pearl River, saw you first, and I'll get to you.
What is the current amount on that that prevents someone from attending?
We actually don't have. It's not prevented at all, lady. We don't have that. This is that whole section's new. Right now, I think it's just violent crimes and. Hold on. Okay. Right now, the only two charges prevented from participating are violent crimes and trafficking drugs. So that whole section is new. Okay. Embezzlement as a whole is still allowed to participate.
Lady, I will further that by saying, in talking with the state auditor's office, I'm aware of one elected official that embezzled $100,000 and was able to go into pretrial diversion. So this is trying to curtail some of that activity. I
like it. It's good stuff.
All right,
lady, we have a situation like that in Pearl River I'll tell you about later.
I already know. Thank you.
Gentleman from Octavia Hall.
Thank you, Mr. Chairman. Is the intent of this to specifically go to elected officials? I noticed you said, okay, you're shaking your head, so I'm assuming that it's anybody that's in that office.
The intent is to any taxpayer money over $10,000 that's embezzlement cannot be going into pretrial diversion. For example, and it's public record. So for example, I have a client who was a justice court assistant assistant clerk who is charged with embezzling about $2,000, very minimum amount of taxpayer money considering what they handle. She would be considered a public official, as you know, but she would also be considered under this to go to pretrial diversion.
Okay, thank you.
Any other questions for the gentleman? Gentlemen, what's your motion? I assume it was title sufficient due pass. You're on mute, but title sufficient due pass. All those opposed? Okay. That motion carries. Gentleman from Rankin, motion to reconsider. A gentleman from Union, motion to table. All right, gentleman from Rankin, if you'll handle House Bill 300.
Thank you, Mr. Chairman. Thank you, members. House Bill 300 is there's no changes in the bill as the way it is, so we're going to ask for a reverse repealer to be put into it. The issue that we're trying to resolve is right now, if you go to jail, you can be held for 48 hours or more, where normally there would be a bail that you could post. Right now, because of the way the Supreme Court rules are being interpreted, you can't do that in different places. Some places you can, some places you can't. We're just trying to resolve that issue, but at the same time, we're working with the Supreme Court to resolve it. So that's the reason we're bringing the language forward, and we'll use what we have to use if we need to use it. That's it.
All right, any questions for the gentleman? All right, and seeing none, gentlemen, what's your motion?
It was, it's titled sufficient due pass as amended.
Okay. Did he offer the amendment? Gentlemen, we had a little trouble hearing. Are you offering an amendment? I just need to adopt the amendment before we pass the bill. Are you offering?
Yes, sir. The amendment is a reverse repealer.
Oh, okay. All right. So all those in favor of the amendment? Okay. All right. The amendment passes. Now your motion is?
Title sufficient due pass as amended.
Okay. Anyone opposed? All right, motion carries. Gentleman from Rankin, motion to reconsider. Gentleman from Lafayette, motion to table. Gentleman from Wayne, I'm going to recognize you for House Bill 634.
Thank you. I've got one quick amendment before I explain the bill.
Recognize on the amendment.
On line 147, after the word municipality, insert comma, including but not limited to bureaus and other local government entities, comma.
That's the amendment. Any questions from anyone? All right. Anyone opposed to the amendment? All right. Seeing none, amendment passes. Gentlemen, I'm going to recognize you for another amendment that we discussed about putting the House Bill 777 language in there regarding the Secretary of State's office.
Yes, Mr. Chairman. That is going to be insert all the language of House Bill 777. It's section 97-37-7. On line 73, we're just including employees of the Secretary of State's office who are authorized by the Secretary to perform investigative or regulatory enforcement actions.
All right, and that amendment, any questions? Okay. Anyone opposed? All right, gentlemen, that amendment carries. Now tell us about the bill.
This bill is the firearms preemption bill from last year. We're simply adding state agencies to the list along with cities and counties. We did exempt let's see here, it's on line, starting on 68, exempted state law enforcement agencies, Department of Wildlife, IHL, as well as community and junior colleges. They had some objections, and so we worked with them to get this language in. I think everybody's happy with that. Further down, there's a little cleanup language through here, nothing too substantial. Starting on line 147 is where the changes to the county and municipalities begin, and it just simplifies or further includes actions that we were seeing some cities or counties take to try to get around some of the provisions in this bill. Following on through, there's no other substantial changes until you get to line 196, and that's gives a mechanism for relief if anyone feels that they've been affected by anyone who chooses not to adhere to this statute. And that's an explanation of the bill.
All right. Any questions for the gentleman? All right, gentleman from Jackson, you recognize.
Thank you, Mr. Chair. Mr. Chairman, since I've been on Judiciary, we have continued to pass legislation making it easier for people to carry guns in our community, and made it harder for our municipalities and counties to protect the people within inside their boundaries. And so one of the things that I hope that this committee is mindful of is that over time, in municipalities, let's just use Moss Point, for example, one of the districts, one of the cities I represent, we've had an uptick in violent crime, specifically gun violence. And we're looking for solutions to cut away at that. For example, just last week, we had a 19-year-old die in the street due to gun violence. 2 weeks before that, we had a 14-year-old shoot and kill a 19-year-old sitting in his car. We've made it so easy for people to obtain guns in our community, and we've made it harder, almost impossible, for our municipalities and counties to preemptively make rules or ordinances to protect their communities. And so, Mr. Chair, as we move forward through this process, and even with this bill, I hope that we'll take that into consideration, because our municipalities and counties really are struggling to protect the people inside of our boundaries. So as we move forward, I hope that the committee takes that into consideration. Thank you for your time, Mr. Chair.
All right, any other questions? All right. What's your motion, gentlemen?
Titles sufficient do pass as amended.
All right. Any, all those opposed? Okay, I see 3, I think. Motion carries. Gentleman from Rankin, motion to reconsider. Gentleman from Wayne, motion to table. That one is gone. Gentleman from Wayne, I'm gonna recognize you for the last one I have you down for, House Bill number 5.
Thank you, Mr. Chairman. House Bill number 5 is the hazing bill. I believe it was passed in some form last year. I'm not sure if this language is the same or not. But if you will, follow me over to line 119, section 2. I believe the first 2 degrees are already law. The difference, the first degree, is when the action actually causes injury. It's punishable by a fine of $2,000, up to $2,000, and not more than 6 months in jail. 136 begins the second degree, which is an action that does not result in injury. It is punishable by a fine up to $1,000 with no jail time. Starting on 148 is where the third degree begins. And this was brought forward due to an incident that happened, I believe, in Louisiana, where a gentleman was led to drink way too much alcohol and I believe ended up dying. And it simply states that if anybody is coerced into drinking so much alcohol that their blood alcohol concentration is at least 30% by weight, this will be a class 3, punishable by up to $10,000 and up to 5 years in prison. And there are some definitions that follow that, but nothing substantial. That's my explanation.
Are there any questions for the gentleman? Seeing none, gentlemen, what's your motion?
Title sufficient, do pass.
All right, all those opposed? Seeing none, motion carries. Gentleman from Rankin, motion to reconsider. Gentleman from Wayne, motion to table. I want to recognize the lady from Harrison for House Bill 883.
Thank you, Mr. Chairman. House Bill 883 is basically what's happening across the state is that law enforcement agencies are requiring their law enforcement to put quotas to issue a certain amount of tickets. This is unfair to the officers as well as unfair to the residents of the state. And if this bill is passed, then it would prohibit those quotas that they are mandated with at this time. I've spoken to a couple of chiefs in the state, and I've also spoken to a few members of law enforcement, and they totally support. Those that I've spoken to totally support. My recommendation is title sufficient to pass.
Motion, any questions before we vote? Seeing none, motion before us is title sufficient to pass. Anyone opposed? Seeing none, motion carries. Lady, motion to reconsider from Harrison. Motion to table, gentleman from Rankin. Okay, the last three, the next one are all mine. The last is House Bill number 196. This is an important bill to me. Dignity for Incarcerated Women's Act. At last count, we had 4 women in the Department of Corrections that were pregnant. And what this bill allows us to do is making sure that our guards, the people at MDOC, the health officials have the proper training, that the women have the products they need, that they have the substances that they need to have a healthy pregnancy. In addition, we are prohibiting for them when they are giving birth or having physical exams from being handcuffed or shackled, and we're allowing them currently. There are situations to where when the infant is born, the mother does not have access to that child. We're giving them access to the child. I think that this is a good bill. The child should not be punished for some of the actions of the mother. And so we want to make sure that the pregnancy is as healthy as possible. So that is an explanation of the bill. Are there any questions? Seeing none, my motion is title sufficient, do pass. Any opposed? Seeing none, bill passes. Gentleman from Rankin, motion to reconsider. Gentleman from Pike, motion to table. All right. The last one is, the next one is House Bill number 163. And that has, I'm going to completely basically do a committee sub on this. It has the code sections in it. It has nothing to do with juvenile offenders. I'm using the code sections here for what we talked about with my judicial district up in Northeast Mississippi. So I'm putting that into this bill. We discussed all that yesterday. Any questions? Seeing none, motion is title sufficient, do pass committee sub. Let me go back. Let me put a reverse repealer in it. So any problems with a reverse repealer? Okay. Motion is title sufficient, do pass committee sub. I don't have to amend that because it's okay. All right. Last bill is
Gentlemen.
it's
I'm opposed to that last bill.
I'm sorry, lady. I couldn't.
I'm opposed to the last bill. I don't think you
Okay.
took a vote on it.
All right. Last is House Bill number 286. This is a cemetery disinterment bill. The proposed bill provides clarity to public and death care industries alike regarding the circumstances for and the process to disinter and reinter remains. Those circumstances include, upon written request, the decedent's next of kin in order of priority, the decedent's spouse, if the spouse has not remarried, the decedent's children, the decedent's parents, decedent's siblings, or by a chancery court order, in order to correct an original internment upon notice of the decedent's next of kin. What we're trying to do here is provide some notice for individual or for decedents, and if they need to be moved, if something happens, we're just giving the family members or whomever next of kin some notice about this. Currently, there were some issues with a potter's field at the University of Mississippi Medical Center. We're just cleaning up some notice requirements, and that's an explanation of the bill. Any questions? Any opposed? All right, motion, if title sufficient, do pass. Any opposed? All right, bill passes. Gentleman from Rankin, motion to reconsider. Gentleman from Tipa, motion to table. Ladies and gentlemen, that is the end of the meeting. I plan to have one. I'll let you guys know Monday. I'm still waiting on a couple of bills. But Monday, I will let you, probably around 3 or after adjournment. I'll let you know. Thank you, guys.